Okay, great. So just so everyone's know, aware recording has started. Super. So again, thank you everyone for coming this evening. A little bit of brief background. So I decided to run this little informal session this evening, just because when I was going through the pupillage application process, there was very little information available on bail applications, pleas and mitigation, how to structure it, what do you do, how do you get through the interview. I picked up a few tips and tricks along the way, which obviously has been quite helpful and has got me pupillage here at Nexus. Everything I discussed this evening is not it's not on behalf of Nexus or Chambers or anything like that. It's say purely off my own back. So please don't sue me or Chambers if anything I say is wrong. And also this is as I say, this is based purely on sort of my experience, and some bits you may find helpful. Hopefully you will. Some bits you may find less helpful, and you're going to need to sort of adapt it to your own style. As well, but I'm going to basically cover the fundamentals of bail applications. What are they? How do we deal with them? How do we structure them? And the same for pleas and mitigation. What are some of the common pitfalls that show up during these kinds of advocacy exercises? How to deal with those, and how to get through the interview. Now, in terms of bail, so bail was looked after in statute by the Bail Act 1976, and there's a presumption in favour of bail. When you're submitting that at your interview, telling the judge there's a presumption in favour of bail is probably not a great thing to do, because the judge is already going to be aware of that. So usually you'll be focusing on the reasons why the prosecution are objecting to bail and why they want bail to be refused. So the reasons that bail can be refused, usually in an interview setting, is going to be focused around an offence that's indictable or an either way offence, and one that's punishable with imprisonment. There are other ones in the Bail Act, but that's likely to be what the focus will be. Also, just forgot to mention, I will do my best to try and get to some questions and answers at the end if there's time. I do need to have a fairly hard stop at 7:30, but if there is time for Q&A, then we'll make use of it at the end. Alternatively, I'll pop my email address in the chat, so if there's any questions that crop up and you want to email me afterwards, then feel free to do so. So yeah, as I say, prosecution, what are they going to be objecting to and why? So they don't want your client to have bail, and the tests that the prosecution need to meet is that the court has to be satisfied that there are substantial grounds for believing the defendant, if they're released on bail, even if subject to conditions, would fail to surrender to custody, commit an offence while on bail, or interfere with witnesses or obstruct the course of justice. So those are going to be your three main objections from the prosecution. And again, make sure that the test is substantial grounds. I've seen in a lot of interviews and a lot of criminal bail application scenarios, and in fact it came up in my interview, that the prosecution had cited the wrong test. They said the defendant will probably fail to surrender to custody, and again, that's the incorrect test. So that's usually your first point. Now, in terms of bail conditions, so how can you deal with those prosecution objections? Usually the best way you can deal with those is by throwing in some conditions and trying to make the judge happy that your client's not going to do a runner. Failure to surrender to custody, commit further offences, or interfere with witnesses. Different conditions fit different objections. Some of those conditions can be bolted onto more than one. Some of them are better suited to only one area. And the conditions have to be necessary, so you can't just throw in a load of random things. They have to be necessary. So some of the conditions that a court might impose, one would be a condition of residence. So a defendant is required to live and sleep each night at a specified address. Condition that the defendant must notify of any changes of their address to the police. There may be a reporting condition. So if the defendant may, you can propose that the defendant has to report to a police station on a daily basis, a weekly basis, or some other interval that you feel is appropriate, but usually daily or weekly is about right. A curfew can usually be quite a good one. So that will be that defendant has to be home between certain hours, and the defendant's fitted with a electronic tag. So that can be usually quite a persuasive one, usually one of the best conditions to go for. But just remember that the court may only impose a tag if it's satisfied that without the tag, the defendant would not be granted bail. So it's quite an extreme condition, but again, it can be a very useful one. You may find in your papers that your client will say something like, I don't want a tag. Your position on that generally is, well, do you want to be in prison while you're waiting for your trial, or do you want to be on tag? Client's going to say, well, given the choice, I'll take the tag. So you might find that sort of situation in your papers, but you can be quite robust with that one. Okay. You can also propose an exclusion requirement, so the defendant not being permitted to go to a certain address or a certain area or within a certain location. Again, when you're reading through your papers in the interview, you can try and have a look and see if the defendant and the complainant are living in the same area, or if they're in different areas. Easier if they're in different areas, but your papers should give you a little bit of a steer. But again, exclusion requirements can be a pretty good one. Non-contact condition is usually a pretty standard one, that the defendant's not to contact directly or indirectly the complainant or any other prosecution witnesses. Generally less persuasive with that one, but it's still worth throwing in there. You can also propose that the defendants surrender their passport to the police. That's mostly suitable for failure to surrender. And that's usually only appropriate if the prosecution have raised some concerns that your client perhaps has connections to another country. If your client doesn't, and there's nothing to suggest that they do have a connection to another country, don't bother with that one, because the judge is going to say to you, what relevance is that? So be a little bit careful with that one. Another two conditions are of surety and security. These again are only applicable really if the prosecution is objecting and saying your client's going to fail to surrender. So your surety is where someone other than the defendant promises to pay the court a sum of money if the defendant fails to answer their bail. Again, have to be a little bit careful with these ones. I've seen in pupillage advocacy exercises before that a surety has been offered by a family member, but they can't quite explain where the money's come from, or where the money has come from doesn't look legitimate. That's a massive red flag. So even if that's being proposed by the client and their family, don't touch it. If something doesn't quite look right where the funds are coming from, don't do it. If it looks clean and simple and fine, then fine, go for it. But just be alert to anything that might make you question the source of funds. Security is where someone deposits money with the court, or possibly some valuables that can be forfeited if the defendant fails to surrender. Again, just be a little bit careful with that and see where funds are coming from and if any assets are being offered. So how do you structure a bail application? I've got a couple of templates that I will share after this evening that I found very helpful when I was going through the pupillage process. And it's quite a handy template because you can tailor it, and it just gives you a nice structure. So there's no real right way to structure a bail application, and people do their applications in different ways. But this is just sort of a general guide and a structure that I find quite helpful. So you can start with your introduction. This should be a very short 1 or 2 sentences, and it should set out very briefly the structure of the submissions that you're going to make. So you may say something along the lines of, this is my application for bail, looking to persuade the courts to grant my client bail, which I'll expand on over a couple of points. You will have the prosecution's objections, so you will know what grounds they're objecting to. So it's again either going to be failure to surrender, commit further offences whilst on bail, or interfere with witnesses. So take each objection in turn and break them down. So objection 1, firstly, are there any substantial grounds for believing that this objection applies? If that's, the court's usually going to be quite open to listening to the prosecution, but what you can do is just counter with what condition can you put in that either removes or substantially reduces that risk. And then you move on to objection 2. Again, are there any substantial grounds for believing that this objection applies? And what conditions can you put in there to counter that? Towards the end, it's a good idea as well to give a little summary of the conditions that you've proposed. Don't have to go into them in massive detail. So, for example, if the issue is failure to surrender to custody, you can say, well, we see why the Crown has raised that objection, but Mr. So-and-so is more than willing and able to comply with the curfew. He'll stay at this address, these times, or as to the times the court sees fit. We'll also propose an exclusion requirement, exclusion zone, so the defendant's not going to that particular area, so he can't interfere with witnesses, again, if that's an objection. So just link your conditions to your objections. And then you can finish off with a conclusion. Should be a very short conclusion, and simply invite the court to grant your client bail and for the reasons that you've identified in the main body of your submissions. So main points to look out for. So failure to surrender. So following points are worth considering if the prosecution objections are under the umbrella of failure to surrender. So have a look through your papers and take a note of the facts. And the most important things to pick out for failure to surrender. Does the defendant have any strong community ties that would prevent them from absconding? So this can be things such as childcare responsibilities, close family members. Do they have a long-standing job? Do they have a mortgage? What factual reasons can you put to the court to say this guy's not going to, this guy's going to come back to court and he's not going to do a runner? Consider how serious is the offence and how severe is the sentence if the defendant is convicted. If he's looking at a community order or possibly a suspended sentence, you could argue, he's less likely to abscond. Again, have to be a little bit careful with that one, but it's potentially a persuasive point. How strong is the evidence against the defendant? Again, if the prosecution have a slam dunk case, your client may be less likely to surrender. Consider that carefully. I have known it to be brought up in advocacy exercises where the judge says, for example, Mr. Martin, the strength of this case is overwhelming against your clients. How can you possibly expect me to grant bail in the circumstances? Your position can be, well, the question before you today, Your Honour, is not one of the evidence. This is before trial. It's up for the prosecution to prove their case and the defendant to put his defence forward. But the application before you today is one of bail. So it's respectfully not Your Honour's job to hold a mini trial and go through the evidence today. So that can be quite a good way of diffusing those kinds of situations. Advocacy exercises. So your defendant is more than likely going to have previous convictions. I've not seen a bail application advocacy exercise in interview where your client doesn't have previous convictions. So that's usually a good place to start. In those scenarios, you'll usually have information as to whether the defendant's been on bail before, and if they have been on bail, whether they've surrendered to their bail or not. Quite often you'll have some of the instances where they have surrendered to bail, and you may have one or two scenarios where they haven't surrendered to bail, but they have reasons for not doing so. Family emergency, dates were wrong, something like that. So again, those are really good factual points that you can say, yes, you know, Mr. So-and-so has failed to surrender on this occasion and this occasion, but these are the reasons why. Got no reason to believe that he wouldn't surrender this time around. Another good one is, has the defendant attended court when he's been required to do so in the current proceedings? If he's been attending every hearing up until now, is less likely, arguably, to suddenly do a runner at the last minute. Does the defendant have a good track record of complying with court orders? Has anything been imposed on your client that you can pick out and say, you know, yes, we know that the prosecution are worried he's going to fail to surrender, but actually he's got a lengthy track record of complying with these court orders in the past. And that can help take the sting out of those previous actions as well. Examples of that would be if the defendants received a suspended sentence in the past, and if so, did they commit an offence during that operational period? So for failure to surrender, conditions you can consider imposing would be a condition of residence, so they have to live and sleep at a certain address, notifying police if they change their address, a reporting condition to a local police station, daily, weekly, whatever you feel is appropriate. Again, passport surrender only really if they've got international ties and the prosecution have a particular objection to that. So that can be fine. Curfew with an electronic tag. Again, curfews need to be a little bit careful with those. So a curfew of 9 hours or more, so between 9 p.m. and 6 a.m., for example, is considered a qualifying curfew. So every 2 days on that curfew equates to 1 day in prison, which will count towards sentencing. So sometimes in certain scenarios, defendants can actually be quite keen to have a tag, because even if they do end up getting convicted, they would already have started taking some time off of their sentence. So again, curfews can be pretty good and pretty persuasive as well. Again, you've got your surety and your security, which are other options as well. But again, just be a bit careful with where funds are coming from in those scenarios. Commit further offences. So if the prosecution says, we're a bit worried your client's going to go out and keep committing more crimes, again, we can find some ways to minimise the relevance of these. So for example, how many offences did your client commit while they were on bail, if they did commit offences while they were on bail? How long ago were these offences committed? Further back in time, the less relevant. Were the offences linked to a factor? Now, this is usually something that often comes up in advocacy exercises, and something that your client will often say, I was dependent on drugs. This is why I was shoplifting all the time to support that habit. Is that no longer present in the defendant's life? Have they gone and got help? Have they been through rehab? Anything they've done independent of the court is always very persuasive. So if they've gone off and signed themselves up for a drug rehab program, super helpful. Other points to look out for. What's the risk the defendant might engage in conduct likely to cause physical or mental injury to someone else? Do they have a propensity to be violent? Conditions you can consider suggesting for committing further offences would be exclusions from the area where the offending took place. For example, if it's a shoplifting offence, you know, they're stealing some stuff from John Lewis, you can have an exclusion requirement around John Lewis. If it's a domestic violence situation or a harassment case or something like that, you can request a exclusion requirement for again, perhaps for the complainant's address. Curfew, again, curfew can be another good one. That can electronically tag your clients, and they can also put a GPS tag on there as well. as part of that curfew. Curfew is very helpful if the offending took place at night, and again, if the court want a little bit more surety that the defendant's not going to go near that particular area, then a GPS tag can be very useful as well. And your final one would be not to contact or associate with certain individuals. That's usually most relevant if there are co-defendants, for example. Interfering with witnesses. So if the prosecution objects on this ground, so they think your client's going to start harassing complainants or other witnesses, how likely is it that the defendant will be able to contact these witnesses? So, for example, does the defendant know where the witness lives or the complainant lives? And does the defendant have any means of contacting them? I came across a situation where both parties had blocked each other on social media, they blocked each other on their phones, the complainant had moved and the defendant didn't know where the complainant was living now. And the prosecution was still objecting to bail because they thought he was going to interfere with witnesses. So in those kinds of situations, you can say, you know, this objection is ridiculous because the defendant has no idea where the complainant is, has no desire to contact them whatsoever. They've blocked each other on social media, and they've blocked phone numbers, changed phone numbers, whatever the facts may be. So it's really just picking out those key facts that can help support your arguments as well. And conditions for those can be not to contact directly or indirectly the relevant witnesses, and condition of residence at a suitable bail address. So somewhere where they're not likely to cross paths with the witness or the complainant. That will usually be evident in your papers. So your client may say to you, oh, you know, if the offending took place in London, but they have a nan or a relative or somebody who lives in Brighton and they can go and stay with them, that's a condition that you can propose and say, well, you know, while we're on bail, my client can go and stay with his grandmother in Brighton, you know, if that's a concern. So that is a whistle-stop tour of bail. I know there's been a couple of questions in the chat box, which I will try and get to before the end of the session, but I just want to quickly rattle through pleas in mitigation, because these are arguably a little bit more tricky sometimes than bail applications. Depends on the facts, but sometimes you're just given a horrendous set of facts and you've got to sort of fight your way out of it. So plea mitigation. So this will be at the stage your client's pleaded guilty or been found guilty after trial, and you're now at the sentencing stage. And at sentencing stage, prosecution will go first, and they will say, we think the offending fits into a certain category, and they will make reference to the sentencing guidelines. You may agree with that category or you might not. More often than not in advocacy exercises, you're probably not going to agree, and you're going to be suggesting to the court why your position should be preferred. So the court's going to have regard to your client's culpability in committing the offence, and also any harm that the offence has either caused, intended to be caused, or might have foreseeably been caused. If you're not familiar with the sentencing guidelines already, I'd strongly encourage you to get comfortable with them. For example, if you just go onto Google and type in, I don't know, GBH sentencing guidelines, and to start getting a bit more familiar with them. Some of you may already be familiar with them. I'm sure some of you already are. Some of you maybe not. But as I say, if you're not, now is the time to get comfortable with them and have a little look. They're pretty straightforward once you get used to them. So the court's going to be looking to punish your clients. They're also considering a general reduction of crime. They're also open and considering rehabilitation, protection of the public, and making any reparations as they may see fit. So navigating the sentencing guidelines, how do you start with those? again, get familiar with them because you need to determine the offence category. And more often than not, you probably won't be agreeing with what the prosecution say. So the category will be determined by two factors, which is culpability and harm. So you usually start with culpability, and it will be determined by what factors are present in the offence. And when you go on the sentencing guidelines, you've got culpability levels, so A, B, and C, for example, and then you have harm, which is usually 1, 2, 3. And then there are certain factors that are present in each category. So you need to read through the guidelines quite carefully. When you're in an interview setting, you will be provided with a copy of the sentencing guidelines and the relevant factors as well. So you just need to quickly read through your scenario and see how they link to the sentencing guidelines. And then you need to be realistic and think, what category does my client fit into? So, for example, you might think, well, you know, it was the culpability, it was a spur of the moment type assault. There was no planning, no premeditation. You know, client just snapped, lost control. So you could argue that culpability falls into the lowest category, which is C. In terms of harm, again, be alive to what injuries are caused or what damage has been caused and how that fits into the sentencing guidelines. So if, for example, the complainant has suffered severe injuries, which is not usually that likely in an advocacy exercise, there'll usually be minor injuries or possibly mild injuries, so cuts, bruises, possibly broken bones, those kinds of things. And again, just have a little look at the guidelines and see which category it falls into of harm. Usually it ends up being in category 2, which seems to capture most things. But yeah, as I say, it depends on the offence, but have a look at the guidelines and see which category you think it fits into. Within the guidelines, there's a starting point and a category range. You don't necessarily have to accept the starting point that's set out in the sentencing guidelines. For example, if the offence just about crosses the threshold from one category into another, you might want to make a submission that there should be a slight downward adjustment from the guideline starting point. You also don't have to conclude that the offence falls squarely into one category. You might, for example, submit that culpability could be between the upper end of B or the lower end of A. So you can straddle the categories if you think, well, it's a bit of both really, and you can sort of gauge what the judge is saying. But if you make either of those submissions, you should be able to justify it to the interview panel, and you should be able to back it up with some facts in the case as well, and the relevant factors in the sentencing guidelines. You'll then have a look at aggravating and mitigating factors. I'm not going to go through all of them because we'll be here forever and a day, but generally speaking, aggravating factors are going to be things like previous convictions. You'll be very, very careful with previous convictions. You'll want to have a look at those very carefully, and you want to have a look at the nature of the offence to what your client is charged with, and the nature of the previous conviction, and how relevant is that to the current offence, and how long has it been since that conviction, since your client was convicted. So if your client has got a conviction, so say your client is up on charge, and they were done for, I don't know, ABH 10 years ago, you can argue that yes, it's a previous conviction, but it was so long ago, it's completely irrelevant. If your client was sentenced for ABH and was convicted of common assault 2 years ago, that's going to be a bit more problematic, because that's likely to aggravate the offence, because it shows your client's got a propensity to commit violent offences. Now, where there's been a significant gap in time between the previous conviction and the current offence, consider if there's a reason for it. So if your client's been in prison for the last 10 years, that might explain why they've not committed any further shoplifting offences. So again, just be a little bit careful with that, because it can backfire on you sometimes. So read the papers carefully. If your client's been in prison for 10 years and you're then saying, oh, well, he's committed no offences in 10 years, it's going to backfire. But alternatively, if the gap indicates that your client has made attempts to stop offending, then the aggravating effect of your previous convictions is going to be lessened. Numerous and frequent previous convictions, again, might constitute an aggravating factor, even if they're a different type to the current offence. But more often than not, in these types of advocacy exercises, they're usually connected to an underlying problem, such as drug addiction, alcohol dependency, something like that. And in those situations, you can argue that those kinds of problems could be addressed more effectively in the community, so a community order. And you could also argue that a custodial sentence isn't going to benefit anybody. If the offence is committed in a domestic context is another aggravating factor. Presence of children, that can be very problematic. Commission of an offence while they're under the influence of alcohol or drugs. Again, you can sometimes spin that to say, you know, your client was addicted to drugs, he's gone through rehab, or he's in a rehab program now, he's trying to break the cycle and get back on the right track. So you can sometimes spin that into a mitigating factor depending on what your case looks like. Abuse of power and or position of trust. I've seen an advocacy exercise which involved a police officer, and the prosecution were very much throwing in this, you know, he's a police officer, abuse of power, abuse of trust. So you need to consider the relationship between the offender and the victim, and one that would give rise to the offender having a significant level of responsibility towards the victim. So again, a police officer, for example. An offence, of course, might be more serious in that situation. Mitigating factors: no previous convictions or no relevant or recent previous convictions, great mitigating factor. Good character or exemplary conduct. Again, it's unlikely that your client will have no previous convictions. 9 times out of 10 they do. If by some miracle they don't, fantastic, all day long with the good character. Remorse. Now, remorse can be a mitigating factor, but the court is going to want to be sure that the remorse is genuine. So have a look through the facts that might provide evidence of remorse. You don't want to be saying that your client's remorseful when they're just really not, especially if there's evidence to suggest that they're not, and they're only remorseful now because they're being sentenced. Use the pre-sentence report. This can be very, very, very helpful. You'll sometimes, well, I'd say quite often you'll get a pre-sentence report as part of the advocacy exercise. Have a careful read through and see what the recommendations of the probation officer are. Sometimes they can be really good for you, sometimes not so good. If they are good for you, make sure that the probation services recommendation is realistic. If it's completely, if they're saying to you, oh, you know, we think you should discharge the client, should be set free, no punishment at all, you're going to want to take that with a pinch of salt. But if it's overly harsh, you'll be inviting the court to move away from the PSR. So it's important to remember the court's not tethered to the PSR. They don't have to follow the recommendations, but sometimes it can work for you, sometimes not so much. If all you've got, if all you have in order to demonstrate remorse is simply the assertion from your client in their instructions to you, might still be worth mentioning it if there's no other evidence to contradict it, but just be aware it might not be your strongest point. If they're a sole or primary carer for a dependent relative or children, something like that, That can be very particularly relevant where your client is on the cusp of custody, or where the suitability of a community order is being considered. If your client's on the cusp of custody, imprisonment shouldn't be imposed where there would be an impact on dependents, which would make a custodial sentence disproportionate to achieving the aim of sentencing. So that could be a very persuasive argument for either possibly a community order or more likely suspending a sentence. So where custody is unavoidable, consideration of the impact on those children may be relevant to the length of the sentence and whether, again, that sentence can be suspended. For more serious offences where a substantial period of custody is appropriate, this is going to carry less weight, because if they in the sentencing guidelines, if they're looking at 6 to 7 years, the court's not going to care too much about the kids because tough luck, one way or another, you're going to prison. And then it's just a case of mitigating that sentence down. Age or lack of maturity. So if your client was particularly young, usually between aged 18 to 25 at the time of the offence, if it's now a couple of years on, then that can be very helpful, very good mitigating factor. The age or lack of maturity, you can submit that young adults, still developing neurologically, and they may be less able to evaluate the consequences of their actions and their behaviour. Plenty of us, I'm sure, have done some very silly things when we were younger, myself included, that you wouldn't dream of doing now. Now, reduction for guilty pleas. I won't go into too much detail because more often than not, usually in these types of exercises, your client's found guilty after trial. So custody threshold, I will touch on very briefly. Again, this can come up quite frequently in advocacy exercises. What's the custody threshold? This is effectively the point at which an offence becomes so serious that a non-custodial sentence cannot be justified for the offence. There's no specific definition of where the custody threshold lies. It's just if in the view of the court, if it's become so serious that a community order is completely inappropriate. Again, that's going to be a bit of a judgment call for you. You may find a scenario where your client's done something not great and you're looking at the sentencing guidelines, and if you're possibly looking at custody of around the 2-year sort of area, you may be looking more down the route of suspended sentence rather than community order. Not necessarily a bad thing to try arguing both, but just make sure you're alive that a custodial sentence may be on the table. And if it is, then you're going to be asking for that to be suspended. What's a suspended sentence? So a suspended sentence is still a custodial sentence, and it shouldn't be seen as an alternative to a more harsh version of a community order. I'm conscious of the time, so I'm just going to skip through a little bit. So most important is what you probably want to know is how do you prepare a plea mitigation before an interview? Like most of these things, there's no sort of clear right or wrong way how to structure it. But a good way that you can structure it, again, similar to bail, is you start with an introduction. So what you're asking for in terms of a sentence. So if you're asking for a suspended sentence or a community order, and a brief summary as to why. You can then go through matters relating to the offence that mitigate the seriousness. So that will be your offence mitigation. And that's where you'll be looking at your categories, you'll be looking at sentencing guidelines, and elements of the offence and the facts of the offence. Matters relating to the offender, so that's going to be your offender mitigations. That's where you're going to be throwing in your personal stuff. He's got children, he's got a job, he's got this, he's got that. If he went to prison, he's going to lose his job, he's going to lose his livelihood. He's the sole carer for his children. It's going to cause them to go into care. It's going to cause all these problems. So separate them out into your offence mitigation and your personal mitigation. And then you can suggest a sentence with reference to the sentencing guidelines. And again, you just back that up with some further facts as to why you think it falls into that category. And then you've got your conclusion, which is usually, if there's anything else, let me know. So, I mean, in real life, I won't touch too much on real life because this isn't real life. So when you're sat there in the room and you've got your papers and you're going through them, think about what culpability and harm category you're going for. So the aim is really to try and achieve the most lenient sentence possible for your client, but it's also got to be realistic. So there's no point asking for a community order if custody is the only way to go. So if you propose a category that's too low, it might mean you risk losing credibility with your judge and your interview panel. When you're looking at aggravating factors, decide if you're going to address any of them up front and in the main body of your submissions. Usually it's a good idea to start with the worst parts of your client's case first. So usually with your previous convictions, get those dealt with and out of the way with straight away. There's no real right or wrong way of dealing with it, but as I say, usually if you can get in there first, deal with the previous convictions or all of the nasty bits and pieces, then you can talk about how wonderful and lovely your client is later. But again, it's entirely up to you how you structure it. Once you've determined your offence category, have a look and see if there'll be any upward or downward adjustments that are likely to be made for these aggravating or mitigating factors, and see if there's any reduction in there for a guilty plea, if your client has pleaded guilty, of course. You'll be able to see whether the court is likely to impose a custodial sentence of 2 years or less, and if so, consider if there's scope to argue that any custodial sentence should be suspended. And then delivering it. So try to speak to your audience, not to the desk in front of you. This goes for pleas and mitigation and for bail applications as well. You of course want to engage with your interview panel. You don't just want to be sat there reading from a bit of paper as you deliver your points. And remember that this is an argument. So you're very unlikely to be able to sit there and give your full submission and say everything you want to say with perfect clarity, and it's unlikely that it's ever going to go exactly the way you want it to go. Because you'll make a point and then the interview panel will throw something in to try and throw you off. There may also be something in the papers that will try and throw you off. Usually that will be an ethical problem. In my interview, I had, I can't remember exactly what the circumstances were, but it was an ethical problem. It said in my papers, your client has instructed you to do whatever it was, and it said in bold and underlined, you have agreed to do this. This is, again, a massive red flag, massive red herring. You don't have to agree to any of that just because it says it in the papers and it says you have agreed to do this. Don't do it. If it doesn't look like a good idea, do not do it, because they'll be trying to trip you up. And sometimes there's not always a correct answer. And sometimes you just need to show your thinking. You don't always just want to rush in and give the first answer that comes to mind. And then as you're talking, a better point comes to mind. And if you're not sure, and if you're genuinely not sure, you can just explain what your process is and what your thought process is. So at least you can pick up a few points by explaining, and showing that you're along the right lines. And don't make things up. If you're looking through your papers and you think, oh, that would be a really good point, but it's not in the papers, don't make things up, because it's never going to go down well. So those are the main bits and pieces that I wanted to run through. So what I'm going to do, I'm just going to show you example So hopefully everyone can see my screen, which I'm sure you can because I've clicked the button that says show your screen.
Johnny, it's very small and it's very compressed. Yeah.
Understood. Okay, thank you for letting me know. Let me try. Is that better?
Far better.
Much better.
Fantastic. Superb. So this is the bail application template that I used during my interview rounds. So got my simple introduction at the top here. Mr. Martin on behalf of, in this case, it was Mr. Forrest. And then they start with the prosecution have objected to bail on the following grounds. So in this instance, it was commit further offences and that he would seek to contact Miss Nichols, who in this scenario was his previous partner, and persuade her not to give evidence. And then we've got a little paragraph of addressing each bail objection in turn. And again, what's my aim? To persuade the court to grant Mr. Forrest conditional bail. And then we've got counter ground 1, commit further offences, so we're breaking them down. So in response to your first objection, I've got 3 submissions to make. First one here, we've got about him needing to collect his 5-year-old daughter and all the dramas and things that it would cause, not just him, but also the complainant if bail wasn't granted. Next one, client's got a respectable full-time job at a shop, and that's his sole source of income. If he's not granted bail, he's going to lose that job, and he would therefore find him in a terrible financial situation. And therefore, this is going to impact not just him, but his mum, his daughter, and his daughter's mother too. So if you can throw in anything that's not just going to impact your client, but it's going to impact others around them, always very helpful. And again, you can then throw in at the end, if the court's not persuaded, we're going to throw in a little condition of curfew in this situation. And I think this actually answered one of the questions earlier. I'd like to highlight to the court, Mr. Forrest working hours 9 to 5, and the alleged incident took question at a nightclub. So an evening curfew in this situation would be most appropriate. Therefore, we submit Mr. Forrest, if granted bail, will not commit further offences. Counter ground 2, that Mr. Forrest would seek to contact Miss Nichols. Again, 3 submissions to make. 3 is usually a good number of submissions to go for. Again, we've got some facts in here. So in this situation, he hadn't spoken to his ex-partner since their relationship ended, and he's got no desire to do so. Doesn't know where she's living, no interest in finding out, blocked him on social media. So again, facts very relevant there. Second objection, again, in these particular papers, wasn't supported by any evidence. The client had shown no attempts of previously trying to interfere with witnesses, didn't try to contact him, his ex-partner at all, so failed to rebut the presumption in favour of bail because there were no substantial grounds for believing that Mr. Forrest wouldn't comply with the bail conditions. And again, always good to have a little backup. So if the court doesn't find submissions persuasive, Mr. Forrest is prepared to agree to a non-contact condition that he doesn't contact Miss Nichols directly or indirectly. So again, this is where your bail conditions come in. We've also highlighted that, yes, Mr. Forrest in this situation does have previous convictions, but he's shown on 3 separate occasions that he's respected and complied with orders of the court. So again, even though you've got some crappy convictions, it's actually quite persuasive to show that he's complied with those conditions. And then a nice little conclusion, because of this, he won't attempt to contact Miss Nichols or persuade her not to give evidence. And then you can have a little summary at the end. So you summarise your interview panel, addressing the first objection that Mr. Forrest will commit further offences. We can put in the condition that Mr. Forrest is under curfew in the evening hours. Second objection, that he's going to interfere with witnesses and try to stop Miss Nichols from giving evidence. Submit that you can grant bail with a non-contact condition. And that deals nicely with the objections. So that's how I chose to structure my bail applications. And I will send this template around to everybody after this evening as well. Just so you can have it for your own records. You can use it, change it, adapt it, do whatever you want. My other one, I'll show you. Plea mitigation. The quality of this is a little bit worse, so apologies. So again, little introduction here. Just confirm that the judge has got a copy of the papers and also the pre-sentence report, and that they've had a chance to read it. Outline the aim of your plea mitigation. So in this situation, to impose a non-custodial sentence. How am I going to do this? So we're going to address the courts on Mr. Malati's culpability, harm. We're going to address the aggravating, the mitigating factors. Mr. Malati's pleaded guilty to, and we're going to look at his personal circumstances at the time of committing the offences. So the judge is already on warning that you're going to be covering all of these bases. And then address firstly in culpability. So we're saying here that in relation to culpability, it's a street robbery and it falls within category C, although perhaps towards the higher end of category C. So it's a relevant submission, but we're still alive to the fact that it's getting quite close towards category B, but we're going to say higher end of C. And why do we think that? Well, there was a minimal use of force, wasn't overly forceful, temporarily restrained. Again, use the sentencing guidelines to help bolster your submissions here. We've got a nice conclusion that therefore, because of this, I submit the factors of category C are present and there's insufficient factors to warrant a category B categorisation. Harm, again, pretty much the same. So in this situation, I submitted that the offence fell within category 3, and that's minimal physical or psychological harm caused to the victim. And again, these are the fact-specific reasons. So the complainant suffered very minor injuries. There was no need for medical treatment. We had some GP evidence that it would only take a few weeks for the injuries to heal. And, you know, there was a bit of a useless fact in here that the complainant was saying she won't go out alone at night and the incident is still fresh in her mind. We just acknowledge that. There's not much we can do about that. The incident happened quite recently. It's still going to be in her mind, but there's not a huge amount you can do about that. But what we can say is that in this situation, the client didn't need any counselling or psychiatric support. The complainant didn't need any counselling or psychiatric support following the incident. So even though she's making a big song and dance that she's terribly traumatised, she's not had any professional support to go through that, nor in this situation did she have any time off work. So again, finish off the submission saying, therefore, falls within category 3, minimal harm. And then you take both of them together. So the culpability and the harm. So we're looking at category C3, the sentencing guidelines in your submissions. And then you can say, according to the sentencing guidelines, this highlights a range of high-level community order to 3 years in custody with a starting point of 1 year's custody. So again, using your sentencing guidelines to see where you're going to pitch it. So that's where we are with sentencing guidelines. You'll then address your aggravating factors and your mitigating factors. So here, for example, the defendant had previous convictions for offences between June 21 and March 23, but all of those offences were as a result of an underlying problem, namely the client's addiction to heroin. While the court will consider this, I urge the court to consider these in the context of the client's circumstances at the time. And his issues, again, could be addressed more effectively in the community rather than in custody. So drug-related offences usually is a good one to go for the community support, community order options. And then we chuck in all of the factors. So we start with offence mitigation first. So in this situation, yep, client's remorseful, but nothing short of a wake-up call for the client, and reference your pre-sentence report, especially with remorse. So you can say probation officers noted an appreciation of the seriousness of the offence. He's very remorseful, and we've got that backed up in the PSR. Police interview, if he's admitted guilt in the police interview, perfect. He's taking responsibility. Again, wake up call. He's accepting of his actions, ready to take responsibility. Determined to address his addiction. Without any direction from the court, he's been attending a local charity for support with his addiction. Again, reference to the pre-sentence report. That can really make your submissions much stronger. Again, because he's also done it off of his own back without any court direction, all the better as well. Age and lack of maturity. Again, he lost his parents at age 14. It was all very terrible, had an awful childhood, and he started off early on a life of criminality at a young age. So again, the age and lack of maturity, very, very helpful. Little to no planning, again, in this particular offence, spur of the moment, opportunity crime, no premeditation. So you can throw that in as offence mitigation as well. Personal mitigation, you can then move on to his personal mitigation and explain how terrible his life is. Lost both his parents, he performed well in school, he's got a flair for art, fashion, textiles. He's been accepted at De Montfort University to study fashion and textiles. His life sadly went off track when he fell into drug addiction. He started smoking cannabis. He's in his final year of A-levels. He's got a bright future ahead. He's got his place at university. Custodial sentence would be, terrible because he's going to lose his place at university. It's going to send his life off on the wrong track. He's had support with his heroin addiction. So all of these facts and things that you can throw in from your papers. I've got quite a lot here. Don't have to go into this much detail, and you probably won't have time in reality in an interview situation, but just pick out your key ones that jump out. If you've got time, you can throw in what the consequences of custodial sentence would be. So again, here he's going to lose his university place. This course is helping support his rehabilitation. It's his motivation for getting clean and getting away from drugs. And then you get to the point where you say what sentence you're asking the court to impose. And again, in this particular situation, what the pre-sentence report was saying in paragraph 4 of the report, again, very, very helpful. 6-month drug rehab, 10 RA days. That was perfect in that situation. But again, just make sure those recommendations are realistic. Your client is, of course, willing and able to undertake unpaid work, throwing himself at the mercy of the court, happy to do whatever's necessary. And then again, just a little conclusion, end of submissions. Oh, that's why I'm just going to stop sharing my screen. Right, there we go. Super. So I'm conscious of the time, and so unfortunately I do have to do a bit of a hard stop this evening, but I hope that was useful, and that was a bit of a whistle-stop tour of bail applications and pleas and mitigation. I will send around the examples as well. Sorry I haven't had a chance to get to your questions, but if you want to take a note of my email address. If you want to drop me any questions that you have, I will do my utmost to reply to you. So yeah, do drop me an email. I'm on residential training this weekend in some godforsaken place doing advocacy training, so I might not be able to respond to you immediately, but I will respond to you. I know it's pupillage interview season at the moment, so please do drop me your questions. Thank you all again for your time. Good luck with pupillage season. I know it's a bit of a daunting time, but yeah, you'll do well. So again, thank you all for your time.
Thank you. Bye.
Thank you. Bye-bye.
Thank you very much.